Hi there. My name is Alexis Eykel, and I'm the Landlord Engagement Specialist here at Tacoma Housing Authority. And this is our final Landlord Lunch and Learn that we are hosting this year with Housing Justice Project. And Will Beck from the Housing Justice Project is going to go ahead and talk to us today about source of income discrimination. Go ahead and take it away.
All right. Good morning, and thank you for the introduction, Alexis. My name is Will Beck. I'm the Assistant Managing Attorney of the Housing Justice Project. Usually on these monthly lunch and learns, I have Jim Henderson joining me. Jim is not with us today, so it will just be me, and I'm going to go ahead and try to share my screen here. Alexis and Lori, do we have a PowerPoint?
We do.
It's looking good.
Awesome. All right. So today we're just going to have a brief overview of source of income discrimination under the RLTA. As we get started here, I'll just give a brief overview of some of the stuff we're going to talk about. I don't imagine that this will be a long presentation, but it's helpful in the sense, in particular, as it relates to rental assistance and other forms of income that you might see your tenants use in trying to pay rent. So we'll start off by kind of going over what source of income means under the statute, under the RLTA. And then once we have a good definition of what source of income is, we can then move into the types of acts that are prohibited by the source of income discrimination statute, and how that impacts, in particular, rental assistance and agreeing to accept rental assistance. There are some additional prohibitions we'll cover after that related to the source of income discrimination statute. And then finally, at the end, we'll just briefly cover what the tenant's remedies are when dealing with a landlord who has engaged in source of income discrimination. So for the landlords in the audience, we're going to talk about the penalties you could face if you are engaging in source of income discrimination. So let's start by defining what source of income means. And we get the definition directly from the statute. It's in the RCW 5918, the RLTA. Source of income includes, under the statute, the following types of benefits or subsidy programs. So it lists specifically in the statute housing assistance, public assistance, emergency rental assistance, veterans benefits, Social Security, SSI or other retirement programs, and any other programs administered by a federal, state, local, or nonprofit entity. So one example that I gave here, which some of us are familiar with in Pierce County, is housing and essential needs. The HEN program. HEN program funds would constitute a source of income under the statute. Now, this list is not an exhaustive list of what's included under source of income for the purposes of source of income discrimination. In fact, the statute explicitly says this is not everything that's included. It merely lists those different sources of income as examples of sources of income that we routinely see, but it does not suggest that there are other sources of income that are not included. That's why in the language of the statute, it says that these are what source of income includes. It doesn't say this is what source of income means. And so there could be other sources of income that would be subject to source of income discrimination laws that are not listed in the statute or not listed on the slide that we just covered. With that being said, one thing that's definitely not considered with respect to source of income discrimination is any kind of income that's derived in an illegal manner. And so without getting into examples of what that would mean, I think a lot of us can reach certain conclusions as far as what kind of sources of income would be illegally derived. Those sources of income are not subject to the source of income discrimination laws. So now we'll get into the prohibited acts regarding source of income discrimination under the RLTA. And it's a pretty long list, so we're just going to kind of parse through it piece by piece. But in general, under the RLTA, a landlord cannot, based on the source of income of an otherwise eligible prospective tenant or current tenant, one, refuse to lease or rent any real property to a prospective tenant or current tenant. So you can't deny a rental property to a tenant solely based on the source of income. However, there is an exception, and it's a pretty limited exception. There are situations where a landlord may refuse to lease to somebody based on their source of income And that's only if the prospective tenant or the current tenant's source of income is conditioned on the real property passing inspection. And in that inspection, it's determined that there's improvements that are required to pass inspection, and those improvements cost more than $1,500. And the landlord has not received any money from the landlord mitigation program that's operated by the Department of Commerce to make those improvements. So in order to justify a situation where a landlord is refusing to rent to a tenant based on their source of income, those three requirements have to be met. Otherwise, it's going to constitute source of income discrimination. In addition, we'll move on to the second prohibited act under the source of income discrimination statute. And this one is the most common, and it's not talked about too much on this slide because we have a whole slide dedicated to it here in a few minutes. A landlord cannot expel a prospective or current tenant from any real property. In other words, you cannot evict or remove a tenant from possession of the property based on source of income. Again, we'll cover that in much more detail as we go through these slides, but I'm covering them in the order that they are listed in the statute. So landlord is also prohibited from making any distinction, discrimination, or restriction against a prospective tenant or current tenant in the price, terms, conditions, fees, or privileges relating to the lease or the occupancy of real property, or in the furnishing of any facilities or services in connection with the rental, lease, or occupancy of real property. And so not only does it say that you cannot discriminate with respect to the terms of the tenancy based on source of income, but you also can't hold out certain services for some tenants and not for others based on the source of income. So you can't, I'll just throw out an example off the top of my head. If you have a situation where a landlord says that parking spaces at the premises are limited, you'd have to be put on a wait list, but you can get moved up the wait list depending on your source of income, or in other words, if you have a particular source of income, you may be moved down the wait list. That would constitute source of income discrimination. There can't be a distinction between the services or facilities that you're offering to one tenant versus the other solely based on their source of income. In addition, a landlord cannot attempt to discourage the rental or lease of any real property to a prospective or current tenant. And the landlord is also prohibited from assisting, inducing, inciting, or coercing another person to commit an act or engage in a practice that violates this section. So to give another example here, a landlord under the RLTA cannot say, I will not rent these apartments to somebody if they have this particular source of income that's covered under the RLTA. Let's say somebody receives SSI. We cannot rent to anybody that receives SSI. That would be a violation of the source of income discrimination statute. But also, if that property owner or landlord is having a representative or some other person seeming to suggest or discourage people that receive SSI from renting from that particular premises, that itself would also be a violation of the source of income discrimination statute. All right, moving forward, there's three more prohibited acts that we'll cover, and there's some additional ones as well, but we'll touch on those at the end. A landlord cannot coerce, intimidate, threaten, or interfere with any person in the exercise or enjoyment of, or on account of the person having exercised or enjoyed, or having aided or encouraged any other person in the exercise or enjoyment of any right granted or protected under this section. A landlord is also prohibited from representing or making representations that a dwelling unit is not available for inspection or rental when the dwelling unit, in fact, is available for inspection or rental. And then finally, it's kind of the catch-all. Landlords are prohibited from, based on the source of income, making unavailable or denying a dwelling unit to a prospective tenant or current tenant that, but for his or her source of income, would be eligible to rent real property. And so that last one there, I mean, it really just summarizes all of the prohibited acts that we've covered in general as a catch-all provision to say, hey, if we didn't make it clear in these other examples of what you can't do based on source of income discrimination, here it is. You cannot make unavailable or deny a dwelling unit to a tenant based on source of income. So I think this slide is probably the most important slide of this presentation, primarily because it covers removing a tenant based on source of income and the eviction process. Part of my take there is biased because I am an eviction defense attorney, but it is the provision of the source of income discrimination statute that comes up the most. And so I cite the specific portion of the RLTA there that prohibits landlords from expelling or removing tenants from possession based on source of income. So in situations where this comes up, I often see it in the context of rental assistance. Mind you, source of income as defined by the RLTA does include specifically emergency rental assistance funds. So rental assistance is a source of income that triggers the source of income discrimination statute. But in a situation where a tenant is approved for rental assistance, does the landlord have to accept the rental assistance funds, even if those funds are contingent upon the landlord's agreement to additional conditions? So let's say you have a tenant who's been found eligible for rental assistance funds. You're looking through the repayment agreement, and there are some terms in there, and you're not sure whether or not you have to agree to those terms or not in order to avoid triggering source of income discrimination. In other words, is it source of income discrimination if I say I don't want to accept these funds because I don't want to agree to these additional terms? And the answer to that question depends. The courts have seemed to suggest, at least in our experience, that if the additional conditions that are required for rental assistance to be accepted impose additional restrictions on the landlord that the landlord would not otherwise be subject to, then the landlord may not be required to agree to those conditions. I think from a landlord's perspective, that varies on a case-by-case basis, and it really depends on, again, what are these restrictions? What are the nature of these restrictions? Are they adding to or restricting you from prohibiting with non-payment evictions going forward? Are they simply reiterating the restrictions that are already placed upon landlords by the RLTA? What does that look like? And depending on the answer to that question, it may or may not trigger source of income discrimination if you deny or reject the rental assistance funds. And then briefly, there's a couple of additional restrictions that are included in the source of income discrimination statute. First, a landlord may not publish, circulate, issue, or display, or cause to be published, circulated, issued, or displayed any communication, notice, advertisement, or sign of any kind relating to the rental or lease of real property that indicates a preference, limitation, or requirement based on any source of income. This language may sound familiar to those that are familiar with the Americans with Disabilities Act. There's similar language in the ADA with respect to the protected classes under the ADA. The source of income discrimination statute basically takes that language and mirrors it to say, hey, you cannot put out advertisements for this unit that you have available that says we prefer if your income is not SSI or your income does not include a Section 8 voucher for the purposes of paying your rent. That would be a prohibited act under the source of income discrimination statute. And then finally, if a landlord requires that a prospective tenant or current tenant have a certain threshold level of income, any source of income in the form of a rent voucher or subsidy must be subtracted from the total of the monthly rent prior to calculating the threshold level of income if the income criteria have been met. So to give an example here, if you're a landlord and you're renting a premises for $1,000 a month, and you have a requirement that the landlord or that the tenant make 3 times that amount in order to qualify for this unit. If that tenant receives a voucher, let's say that voucher is $500, that has to be factored in calculating that income threshold. Otherwise, you may be engaging in source of income discrimination. And this next slide is just really quickly goes over the tenant's remedies. The reason as landlords we want to avoid engaging in source of income discrimination are because the penalties can be pretty severe if a tenant decides to bring an action for source of income discrimination. Under the RLTA, a landlord who engages in source of income discrimination can be held liable in a civil action for up to 4.5 times the monthly rent of the real property at issue, as well as court costs and reasonable attorney's fees. So 4.5 times the monthly rent is pretty significant. I'm trying to think off the top of my head if there's any other remedies in the RLTA that are more severe than that, but I think that may be one of, if not the most severe penalties for landlords. So just as a matter of good practice, usually I would rely on Jim to pitch in here on landlord best practices. But I think, if we're for the landlords in the audience, be very careful with how you are treating different sources of income, and keep in mind that the source of income discrimination statute is more likely than not going to apply to any source of income unless it's income that is derived in a legal manner.